Thank you, Madam Chair. And yes, we have returned to this particular bill. And Madam Chair, just so I can kind of keep my thought process and work through this bill systematically as well. The last time we left this bill, we were talking about, or I was talking about Section 6, which is Section 9 amended around aggravating factors, and also just to signal to you as well, to the Chair, that I still haven't received a response from the Minister regarding my previous question, which is around subsection 1CB, including Section 66, 1B, C or D, or 2 of the Crimes Act 1961 around party liability. Madam Chair, I've asked at that stage 2 questions, just also to jog the Minister's memory. I asked 2 questions. One of them was, how would this work in reference to the Arson and Queen case of 2014, whereby the fact that in Aotearoa currently under the Crimes Act 1961 and particularly Section 66, we do not have a complete withdrawal possibility when it comes to party liability, which is very clear in that Supreme Court case. The second part of that would be that when we're looking at party liability as well, considering that we have removed the presumption whereby a person who is married, in most cases, a woman who is married to a husband commits a crime, that they automatically get the defense of convulsion. To that effect, that with that presumption being removed, there is nothing in this bill or under Crimes Act 1961, Section 66, that would allow a defense for someone who has been in long-term abusive relationships, and how that would be punished both under Section 66 as well as under this new aggravating factor. So just want to get clarity from the Minister on whether that has been taken into consideration when this has been decided. The next part I want to mention in terms of the aggravating factors is one of the 2 aggravating factors that has been introduced as a part of this bill. Now, this is Section 6, subsection 2. Understandably, FC, that makes a lot of sense. We're putting that public transport service workers online with other service workers such as police and emergency and firefighters, etc. I would like to ask the Minister some questions around subsection 2FD, and that is to do with when one of the following happens, when the victim is working on their own, or when the victim is working in a business that was physically joined to. Now, one of the things that we did explore and did actually came through as part of submissions by others was around the fact that that is already an existing aggravating factor under Section 9 of the Sentencing Act, and that is, from memory, 9G, where it says that the victim was, 9G, where it says the victim was particularly vulnerable because of his or her age or health, or because of any other factor known to the offender, which could extend to knowing the victim was working alone or working in a business. Now, how would the Minister reconcile with the fact that for something like that, if both aggravating factors are being considered, that would be considered a double jeopardy or a case where a person will be trialed or be punished twice for potentially the same crime? Will the judge have a level of flexibility in that case to determine whether they will apply the aggravating factor FD or the aggravating factor 9G? So those 2 questions, one around party liability under Section 66, and the other one around the new aggravating factor FD.
Madam Chair.
Honourable Paul Goldsmith.
Just, thank you, members, for the questions. In terms of the youth discount, the member referred to fetal alcohol syndrome and so forth, and those matters can be dealt with separately from youth. The youth discount applies to offenders aged 18 and over, and so our point of view is that they should have the potential for a discount for that youth once, not multiple times. And we tend to look at it from the point of view of the victims of crime. It doesn't really sort of matter if you're violently assaulted by somebody, what age they are, you are violently assaulted. So we wanted to send a clear message that we're limiting the amount of discounts that can be applied when it comes to sentencing. In terms of party liability, my advice is that party liability is determined at the conviction stage, not in sentencing.
Yeah, I mean, there's a lot there to unpack. Basically, Lawrence is asking the question, what do victims want? And he's also asking about double jeopardy. I don't have an answer for the double jeopardy part. That's something that I'd have to dig much deeper into. But I do know this, that in the regulatory impact statement, it did go over what victims wanted. And it made the point that victims are not a homogenous group and that their needs vary. And that quite often they're in favour of restorative justice, which is very interesting when you look at the regulatory impact statements. But yeah, another point that it was made in the statement was that simply imposing longer prison sentences may not address the factors that make people feel unsafe, and that research shows that early prevention programs have effectively reduced long-term criminal justice costs. So it actually saves money to have prevention programs. Changing the law to encourage longer sentences alone may not tackle common causes of offending, such as history of antisocial behaviour, neglect, abuse, low education, unstable employment, and substance abuse. So, yeah, this bill alone, by simply just dropping the amount of discounts that you can have, restricting it to 40%, is not going to make society safer. You're still going to have people that are going to be leaving prison and going to be committing crime in the future because you haven't addressed the root cause of it.
Yeah, exactly.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.